Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. Now I'd like to present Judge Murphy. Judge Kevin Murphy brings to his ADR practice 28 years of experience as a judge in the California Superior Court, Santa Clara County, during which time he supervised both criminal and civil divisions. And before his ascension, Judge Murphy spent 9 years as Deputy District Attorney in Santa Clara County. Along with being an adjunct professor at the Santa Clara University of Law School for 9 years, the Santa Clara University Law School for 9 years, Judge Murphy served as supervising civil judge in 2008 and was awarded a Lifetime Achievement Award by the Santa Clara County Trial Lawyers Association in May 2012. As a full-time neutral since 2011, Judge Murphy has been one of ADR Services, Inc.'s most sought-after neutrals, performing multiple services, including mediator, arbitrator, discovery referee, special references, and mock arbitrations, along with trials throughout California. His practice areas range across the breadth of legal dispute types, with particular emphasis on employment, business, and real estate matters. I will post the link to the materials so you can download the PDF attachment in just a moment. And I will turn it over to Judge Murphy.
Thank you. And Happy New Year. Good afternoon to you all. I am coming to you from my dining room. Thanks to Zoom and COVID-19, things have really changed, as you know. In the background, you will see a portrait of my wife's relatives. They are keeping an eye on me and will report to her should I say anything that she might take offense to. By way of a heads up, I will mention to you that I have a cat named Maxwell who may put in a cameo appearance this afternoon. I've got food next to me that I can slip to him if he starts meowing. So be prepared for that. You know, one of the things I've noticed about Zoom and in the context with mediation, and I think other mediators have noticed this as well, as we had a great fear in the beginning that if we didn't have in-person communications, then we couldn't be effective at doing mediations. I have found that not to be the case. I think a lot of my colleagues have as well, and the attorneys that I've dealt with. Zoom presents a sort of informality that we didn't envision. As a result of Zoom mediations, I have had the opportunity to meet family pets. I've met children. Yesterday, an attorney was changing diapers on a 6-month-old child. And in a recent mediation, which was coming from an attorney's kitchen, his wife was preparing dinner in the background. She became involved in the mediation, advised me that she agreed with me, her husband was unreasonable, and she facilitated a settlement of that particular case. So it's really a new day in communication as it relates to all aspects of the law. But let me get down to the topic at hand, which is competency. Years ago, I had a colleague that sat with me on the Superior Court in Santa Clara County, a really interesting guy. He was a former San Francisco police officer. He received commendations, including one where he and his partner were asleep in their patrol car on duty, and a burglar fell from the 2nd floor, woke them, he made an arrest, and they received a commendation. We worked together in the district attorney's office. He became a judge and was a very interesting character. He always drove to work in this big black Cadillac. one of the old-fashioned types with the fins. He would get out of his car, and his attire was such that he was generally wrinkled. I call it a clean wrinkled look. He would come into the court building, arrive in his chambers at about 5 minutes to 9. He would reach in his top drawer and pull out a clip-on tie, put that on. It was the same tie he wore every single day, and take the bench. Besides being interesting in behavior, he was interesting in some of the language that he would use. He would tell attorneys during settlement conferences, if he thought their case wasn't very good, that they had a chicken shit case. And when we would attend training together, and of course, judges for years have gone through training, which covers everything from sexual harassment to bias to topics similar to what I will be addressing today. If he didn't like the course, he didn't like the material, he would say, this is a bullshit course. And sometimes during the presentation, he would mutter, this is a bullshit course. Well, in preparing for this presentation, I wanted to make sure that it wouldn't be a bullshit course. And it occurred to me that I have somewhat of a captive audience because most of you, if not all of you, are out there because you need your MCLE credits. And in going down the list of requirements, you came across one unit for competency. You probably figured, well, I'm stuck with it, so let me see if I can put my head down and get through it. Maybe I can slip away and have a couple of beers as part of the progress, but it's something I have to do, but it's probably not worthwhile. Well, one of the things I want to communicate today is this is a very relevant topic. There are problems facing our profession that I want to address in talking about competency. These are problems generated by substance abuse, and by substance abuse, I'm referring to abuse caused by alcohol or drugs, legal or illegal. And we face mental health problems, generally described by those who survey attorneys regarding these issues as consisting of depression, anxiety, and stress. There's a real problem out there. I want to talk about it. I want to also point to potential solutions to the problem. And then I want to shift in another direction and look at the subject of the legal and ethical consequences of situations where competency problems arise. So let me begin with some statistics and studies which I have come across. The general public, according to surveys, consists of a group of people where 7% suffer from substance abuse. 6.7% suffer from depression. Now that's alarming in and of itself, but when you examine the numbers that apply to attorneys who practice law, you immediately notice that we have a bigger problem. We attorneys, and I'm an attorney again, after I left the bench, I had to re-up with the Bar Association. We attorneys are 3 times more likely to develop substance abuse problems and 4 times more likely to develop depression. Now that's really alarming. The leading study on this subject was conducted by the American Bar Association in conjunction with the Betty Ford Institute. And basically, the study revealed the following statistics. In terms of alcohol abuse within the profession, 21% of the attorneys in this country suffer from alcohol abuse. On the mental health side of things, 28% suffer from depression, 23% suffer from stress, and 19% suffer from anxiety. As it relates to these problems, The problems are more prevalent among attorneys who are under the age of 30. Males are more likely than females to suffer from substance abuse, but perhaps surprisingly, women attorneys are more likely to suffer from depression than male attorneys. By the way, I made reference to the fact that surveys of the general public and attorneys that address mental issues address them in 3 separate categories. Let me just comment briefly on those categories. And before I do, let me assure you, I'm not a doctor. I'm not specially trained in medicine, psychology, or psychiatry. These are statistics which I came across and information which I gathered from doing research. Stress. Stress is not considered to be a mental disease. We all suffer stress, hopefully not every single day. Anxiety is somewhat similar to stress in the sense that in and of itself, it's not a defined mental illness. On the other hand, anxiety taken to an extreme, such as consistent instances of panic attacks, does qualify as a mental illness. In terms of depression, it's important to understand the meaning of that term in connection with mental illness. We all loosely throw around the word depression. Coming home after a long day saying, you know, this was a stressful day and I'm kind of down, I'm depressed. And there are many instances in life when we're sad. If we lose a loved one, there are moments of sadness. But clinical depression, which is one of the terms for the illness, consists of a situation where there is this ongoing feeling of depression, feeling down, feeling worthless, not wanting to do anything in life. That is the mental illness that is being addressed in these studies. Perhaps the best way of describing depression to you that maybe some of you can relate to, or somebody that you know can relate to, is you could have a situation where you awake on a Saturday morning, seemingly with no care in the world. Everything is going well at work. Your family life is terrific. You have a wonderful spouse. You have wonderful children. If you're into sports, your favorite team won the previous evening. There's absolutely no reason to be down. It's suddenly you feel terribly, terribly sad. You don't know why. You can't explain it. When asked about it by your spouse, you can give no logical explanation as to why you should be sad. Nevertheless, you are. And this unexplained sadness continues almost on a daily basis. Fortunately, there's help for clinical depression, but that's kind of a description of what the situation can be like. Well, one logical question to pose at this time, and one very important question, is if we in the legal profession have such significant problems in the competency area because of substance abuse and mental illness, why is it that our statistics are dramatically more significant than those in the general public? Why are we suffering mental illness? Why are we going through substance abuse? Why is the suicide rate of attorneys higher than other professions? And that's another fact that's a given. We're not in the #1 position. For some reason, dentists are, but nevertheless, we have a higher suicide rate. Well, in examining some of the writings on the subject, there seems to be 3 different things that has contributed to the problem that exists in our profession. #1 is law school. The thinking is that law school, like any other graduate program, can involve a high pressure situation where a number of students who have excelled maybe at the collegiate level come into an environment where they all can't be number one, they all can't get A's, they can't all be at the top of the class. Instead, maybe they're a C student. On top of that, there's the pressure involved in learning, in test taking, and probably the most extreme pressure of all is thinking ahead about trying to find a position. Maybe you want to work at a top law office. You know you're going to have to really do well in law school. So these things combined together, perhaps enhanced by the Socratic method, has led to many to believe that at least the problem we have in our profession is caused by law schools. I saw one study that was conducted of 15 law schools that indicated that among the students, 25% were at risk for alcoholism, 17% were suffering depression, and at least 6% had thought about suicide in the prior year. So those certainly are alarming numbers. The second reason that I have encountered in doing my reading about why it is that we have these problems is that lawyers have a tendency to identify with their clients' situations. And most clients come to lawyers because they have problems. Maybe you're a criminal practitioner and you have to deal with the ugliness associated with crime. Maybe you have to deal with dissolution of marriages, custody issues involving children, really depressing stuff. A lot of forms of civil litigation involve sad situations, serious accidents causing injuries, sexual abuse. So we have the tendency to work with people who have problems, and as a consequence, we suffer from those problems. So that is one of the reasons that is given as well. The third reason that I'd like to make reference to, and I'm going to refer to a study that I think is really interesting, although I somewhat question some of the numbers they came up with. But the third reason for the problems in our profession is the what has been described as the law office culture. And what is being addressed by those who write about this is what happens in medium to large law offices and to some smaller law offices where there are multiple individuals involved. There was a study conducted by ALM Intelligence, and this survey addressed students or law students associated with law firms, as well as attorneys in law firms in 200 large law offices in the United States. And the people surveyed were asked to comment on certain things that occurred within the law firm itself. 90% of those who responded to the survey indicated that there were alcohol problems in the office. 48% indicated that there were drug problems within the office. 86% indicated depression was a problem in the office. Now, I was shocked with the high numbers, and I questioned the high numbers. Not everybody responded to these sorts of surveys, which is typical. But I think the point that we can gather is that the culture in a law office perceived by those surveyed presents some real problems. One other statistic that I came across, which probably is not going to be surprising to any of you attorneys that work really hard, is that 67% of those surveyed indicated that the practice of law in the law office interfered with their personal relationships. And you can imagine how that can occur. You work extra hours, you work on weekends, you're constantly subject to calls, and whether it be from clients or superiors, you can imagine that that's the case. As part of this same survey, those who indicated their observations were asked why the environment existed, what were the reasons, what led to depression, substance abuse in the law office. And here's what they listed. Number one, in terms of the cause of the problem, was the fact that they were, quote, always on call, meaning that if they weren't at the office, they were at home, no matter where they were subject to being called on a case. And of course, some of those situations involved individuals that were called even on vacations. There are some companies you can work for that boast of vacation days, yet if you attempt to take them, number one, sometimes someone looks at you as if you're not a team player by taking the vacation, and then sometimes you're called on vacation. The number two reason listed by those who participated in this survey for the conclusions that they arrived at, and I thought this would be number one, was the pressure over billable hours. I can imagine it's rather intense, especially for new members of a law firm. They want to succeed, they want to advance, they want to be a partner someday, and obviously you have to produce. So there is definite pressure felt, I would think in general, and according to those who participated in the survey, because of billable hours. Going down the list with just the two next items, lack of sleep. And that's obviously tied into the first two items. Lack of sleep because of the work contributed to the problem. And then finally, client demands. In thinking about problems in law offices, and the attorneys that seem to perceive the problems in greater number are the associates, junior, senior associates, more so than those who are established. But I think about what I've sometimes described as the plight of a new attorney. I remember years ago, and believe me, it was years ago, that I started in the Santa Clara County District Attorney's Office. Now, I wasn't in a big firm. I wasn't charged with the responsibility of producing money. I didn't have to worry about billable hours. It was very exciting to be young. I was in my 20s starting that job. Nevertheless, there was a certain camaraderie and to a certain extent an expectation that after work you go out and you go to a bar. And I would join in, I would go to bars. There was always free food. There was always somebody to tell war stories and puff up the impact of their latest closing argument. But nevertheless, I got into that habit. I wanted to fit in. I wanted to be a team player. Now, if you shift over to law firms, private law firms, you encounter a similar situation. New lawyers are going to be asked to go out for a drink after work. If it's the new boss, do you say no? Maybe you don't drink. Do you say, I'm sorry, no, I don't drink, I won't accompany you? And what about if after hours at the bar involves meeting with clients? So there's got to be a pressure there for new attorneys in particular who want longevity in the law firm to deal with that situation. Well, next the question becomes, how do you deal with this problem? First of all, I think we have to recognize that there is among some a great misunderstanding about things like depression or alcoholism. Many people regard it as simply a matter of moral weakness. Those individuals would say, hey, if someone wants to quit drinking, just do it. Well, just put the drink down. Show some commitment, show some inner strength. In terms of depression, the reaction would be, oh, this person's off work due to depression, assuming that information is not protected by privacy. Well, I get depressed sometimes. Why don't I take time off? They don't take these conditions seriously. They don't understand that real addiction is not something that's simple to deal with. And that genuine depression, clinical depression, actually exists. Let me admit to you that at different times in my life, I have been victim to not understanding substance abuse and not understanding depression. Let me share one example with you. My mother's father suffered from depression, and when she was very young in her teenage years, he committed suicide. It devastated her. Her father was the person she was closest to. Her mother fell apart and had what was then described by the popular terminology, nervous breakdown. My mom at the age of 15 and 16 had to take over family matters. Shortly thereafter, she continued with it as she went to college at UC Berkeley and used to take the ferry from San Francisco to UC Berkeley, while at the same time trying to hold her family together. When I heard about that and I saw what it did to her, I hated my grandfather, and I had not ever met him. I have to wonder about any person that hates someone you don't know, but I did. And it took me years to get over the mistaken notion that people who are depressed and commit suicide are cowards and taking the easy way out. I got a real lesson in reality years later when I was on the bench and a member of my staff suddenly had to rush home because of an accident that occurred at her house. The accident turned out to be the fact that her husband, a person that I knew very well, a very outgoing, likable person, I officiated at their wedding, committed suicide at their home in the backyard, probably 6 feet away from the location where the wedding was performed. I got there, the coroner's office was there. I saw certain things that I'll never forget. But one thing I did do at that point is try to learn about depression. My friend explained to me that this wonderful, happy man, for no reason, suddenly became depressed, started crying for no reason, would not get out of bed. She tried to get him help. It didn't work, and his life ended. From that point onward, I think I've taken a healthier look at depression. I've forgiven my grandfather, and I've learned that depression is the product of several things. It can result from an incident that happens in early life. It is a product of things that go on in the brain that I don't even understand. And it's much more complicated than chemical imbalance in the brain. That's become a myth, an overstatement. And then heredity has something to do with it. If your parents or siblings suffered from clinical depression, there's a 40% chance that you will do that, you will suffer that as well. So that's really alarming. That's really alarming. Well, what about getting help? Where can we turn? Any of us, whether it's for ourselves or someone that we know. Of course, there are a number of agencies out there that can render assistance. I've listed some organizations with phone numbers in the material that was handed out. I didn't list various suicide hotlines. I didn't specifically mention AA and NA, organizations that really are not out for financial gain, but to help people. I listed in the handouts the phone number of the Lawyers Assistance Program. You can contact them. There's some online counseling. They can direct you to counseling that involves live-in sessions, and they can provide certain financial aid. There's the other bar, participated in by law students, lawyers, and judges. I've listed that number. The State Bar's Alternative Assistance Program, which is part of their disciplinary function, has a program where, in essence, these sorts of problems can be addressed. And by the way, one statistic that I came across is 1/3 of lawyers that are on probation for disciplinary reasons, substance abuse was involved. One other statistic that I'll mention to you, when you look at malpractice and you combine that with discipline for ethical violations, 60% involve substance abuse in some form. In terms of the help that I've mentioned to you, I will indicate I'm come across some suspicion and lack of comfort by attorneys with the State Bar Association, viewing them as a disciplinary organization. And they're worried about contacting. And consistent with that, only 6.8% of lawyers with the problems that I'm discussing with you ever seek help. And they're especially reluctant to seek help from the State Bar Association. Again, this is information I've come across, and so personally I can't comment on whether the deterrence actually exists. Well, I'd like to now turn to the question of what responsibility do we have, or do other people have, for substance abuse problems that develop. And here I will be zeroing in on the subject of competency within the context of the California Rules of Professional Conduct. And I will be simply referring to the California Rules of Professional Conduct as the rules. So when we look at legal and ethical consequences, we're looking at the ethics rules, and we're also looking to the subject of malpractice. If you look at the basic competency rule, it's Rule 1.1. That begins by telling us something that we were aware of, whether we had to read this or not, that if you fail to perform legal services with competence, you violate the rules. Whether it be the product of an intentional act, gross negligence, recklessness, or repeated conduct, which to me would amount to simple negligence. That's a violation of the California rules. It subjects an attorney to discipline. Interestingly, when you look further at the definition of competence, and you go to Rule 1.1b, you learn that competency means that you need to operate with a reasonable skill. And in terms of that, you have to operate with a learning skill, mental, emotional, and physical ability that is required under the situation. Note reference to mental, emotional, and physical disability. Rule 1.16, which is the rule that deals with when one should decline accepting a case and when one should withdraw from a case, that advises lawyers that don't accept a case, withdraw from a case if you can't perform the job due to mental or physical condition. So if your mental condition due to mental disease or defect, your impairment reaches the point where you cannot do your job, you can't take the case, or you have to withdraw. There's a distinction between when you're obligated to and when it is permissive, and the two is distinguished with the differentiation between whether the mental or physical condition renders it difficult or renders it unreasonably difficult for lawyers to do their job. If it's unreasonably difficult, you can't take the case, you must withdraw, otherwise it is permissive. To go and take this topic a step further in terms of responsibility, really for the acts of others, let me present you with a hypothetical situation to illustrate several points. I've entitled this hypothetical situation, One Toke Over the Line. In this situation, a lawyer works in a law office and has a friend, and they're close. They started on the same day, and the friend has both a drinking and a marijuana smoking problem. That is to say, they drink to excess. They're known to be high after hours when doing late night work. There's a rumor in the office that this individual once late at night snorted a line of cocaine off the managing partner's desk. So you're dealing with that sort of individual. One evening, this lawyer encounters the attorney with the substance abuse problem and notices that he is high. And he indicates that he's got a major trial coming up the next day, and he's pulling an all-nighter to get ready for opening statement. The attorney says to his friend, well, you know, you appear to be feeling no pain, you appear to be high. Do you really want to do this? And the response from the individual is, don't worry, I've taken a couple of my wife's Vicodins and I've got 3 joints to last me to sunrise. Question, what does the lawyer who counters his friend do? Well, one, you could try to personally counsel him and say, don't do this. But people with substance abuse problems and many people with mental health problems will not admit it. Next option, do you contact someone in authority at the law office? I think the answer is yes. There is no ethical requirement under the California rules that you have to report. Now, distinguish that, however, between a situation where you aid and abet what the person's doing, or there's one provision in the rules of 5-point, I think it's in the 5-point section, saying that you can't order it or ratify the behavior. But short of that, in my situation, there would be no responsibility to report. However, I'm suggesting to you that for malpractice reasons, you need to go to a person in authority. You can just imagine if there's a malpractice case dealing with this attorney's handling of the litigation, and it comes out that he was suffering from substance abuse, and somehow the party initiating the lawsuit finds out that the office was aware of it and did nothing, that is not going to go over well during litigation. So contact authorities within the office. In terms of contacting the police or the Bar Association, there's no requirement to do that. I was discussing this topic at a law office once about responsibilities to report. And at that, and just as I got into the topic, the senior attorney in the office stood up and said, "We'll have no snitches in this office. We don't snitch." Well, nobody likes the term snitch, stool pigeon, or the like. But I think there's a responsibility which is owed to a client, a duty of loyalty, a duty of competency. And even if there's no requirement in my hypothetical to call this to the attention of anybody, at a minimum, you need to call it to the attention of someone in a position of authority. Let me bring up one additional hypothetical, which I entitled 911 from Department 24. The scenario is this. You have two lawyers who are trying a case, lawyer number one and lawyer number two. It's time for closing argument. Closing argument will occur at 1:30. The two decide to go out to lunch, and the attorney in seat number one starts drinking, puts down about 3 martinis, and it's apparent to attorney number two that he's intoxicated. He's also been known to carry a flask. At that point, attorney number two says, "Hey, you can't give a closing argument like that." And the intoxicated lawyer responds, "I could give a closing argument. I can win this case standing on my head." Well, the second attorney is very concerned for a number of reasons, including the fact this guy may actually try to stand on his head. So he has a situation where he has to act. Well, he could try to talk the attorney out of delivering the closing argument. Let's assume that's unsuccessful. At that point, it is more than wise for him to contact the office and seek a person in a position of authority. When we look at the rules that apply to dealing with the acts of others, we encounter reference to managerial authority and those who act of direct supervisory authority over other lawyers. If you're a manager, among other things, you have to make reasonable efforts to assure that the firm has measures to reasonably assure that the lawyers in that office comply with the rules in the State Bar Act. That generally involves things such as putting on classes that address issues similar to what I'm addressing with you, as well as other topics like sexual harassment. There is that responsibility. But the manager, not by definition, not being a supervisor, there's no direction that he or she take any particular action. However, there is a provision in the ethics rules which provides that if this manager knows about the situation and at a time when the consequences can be avoided or mitigated, that person needs to take reasonable remedial action. So in my situation, if the communication goes to the managing partner, she must take reasonable remedial actions. If lawyer number two contacts a direct supervisor or one who's deemed a direct supervisor, the supervisor has certain responsibilities. Unlike a manager, the supervisor is required to make reasonable efforts that the person that she supervises adhere to the ethics rules in the State Bar Act. And by the way, that includes lawyers from other firms. If that lawyer is supervising a lawyer from another firm in connection with some sort of joint prosecution of a case, then there's responsibilities there. But the supervisor, like the manager, is subject to the rule that I just made reference to. And we're talking about rules 5.1A through 5.1B. That is to say, if there's knowledge, if there's an opportunity to avoid consequences, to mitigate, direct remedial action must be taken. Well, the question then becomes, what constitutes direct remedial action? In my hypothetical, I'm going to suggest the following approach. If attorney number one will not back down, and if he gets on the phone and denies he's got a drinking problem or he's impaired, I think one direction is to seek an adjournment until the person is prepared to present a closing argument in a competent fashion. Now that's going to require a visit to the judge, which presents all sorts of interesting issues. When you ask for an adjournment, what do you tell the judge? Well, you're required ethically to tell the truth. So you can't say that I have a sudden migraine or anything of that nature. You're required really to say, hey, I'm embarrassed, but I'm in no condition to present the closing argument. Of course, the judge can say no. Judges do that sort of thing, as you're well aware. What do you do in that situation? Well, I think the backup plan is if the judge has said this case is going to go to the jury, then you direct attorney number two, the second chair lawyer, to take on the problem and do the best you can in presenting the closing argument. Let me shift in a slightly different but related direction. And I'm trying to keep an eye on the time situation here, recognizing there may be some questions. And I know Katie will jump in and tell me when it's time to not say anymore. But the judiciary, judges have similar problems. If you look at the situation, like attorneys, judges suffer disproportionately when compared to the general public from mental illness and alcoholism. Judges have requirements that they must act competently. Under the California Code of Judicial Ethics, judges can be censured under the state constitution for habitual intemperance resulting from intoxicants or drugs. Judges have certain responsibilities to report other judges that are not performing competently. But what I really thought about in particular, in terms of a subject to be addressed in this area, is to focus on the attorneys and pose and try to answer the question, what do you do with an impaired judge? Years ago, there was a judge, and I mean a lot of years ago, this person is not around anymore, who had the nickname Judge Sauce. And if you're not familiar with the term, it came from being on the sauce, which means drinking. And this judge had a drinking problem off the bench and on the bench. And by the way, we judges know that you lawyers have nicknames for us. So, and we're well aware of them. Some of my favorites include names such as Judge Witless, Judge Clueless, and Job of the Judge. I've even heard that one. But in any event, this particular judge one day was presiding over an arraignment calendar. And for those of you who are not familiar with what constitutes an arraignment calendar, that's where there are a large group of people, most of them in custody, in court. They're being advised of the nature of the charges against them. And of course, the first thing that happens is the judge calls their name. Well, this judge would call the name of somebody to be arraigned and ask them, well, what's your nationality or background? The person said they were from Mexico, the judge would speak some Spanish. If they said they were from Vietnam, the judge would speak Vietnamese. Any language, he would address them in their language. Now, on the surface, that looks to be very impressive. The problem is the judge didn't speak any of these languages. It was chaos. I've never been in a courtroom situation before where the presiding judge and another judge, both wearing robes, took the bench and basically escorted someone off on the bench. Well, we thought it was funny at the time. I was young and immature. It's really not funny. It's not funny at all because this person was really suffering. And what really concerns me is, what do you as attorneys do if you encounter an impaired judge? I think there's two situations. And situation number one is if there's a threat to your client. You're in trial and the judge is impaired. You've got to take action to protect your client, even if it means going on the record and memorializing the fact that the judge is impaired. You just have to do it. You may not want to. You don't want to do it in front of a jury. You could do things off the record, but I think you have to protect your client. On the other hand, if there's no direct threat to your client, then you can take other steps, such as trying to talk to the judge if you know her, getting a friend or judicial colleague to talk to the person, or ask the supervising judge to step in. I see Katie has appeared,
Yes.
and
Yes,
I'm
Judge.
surmising that she's about to signal me to wrap things up.
Mhm.
And there may be some questions out there. So as always, I'm going to follow her direction and simply say, I hope some of the information I presented to you is helpful. Before I did this, I reviewed 4 competency presentations, and a lot of them were not too worthwhile. One, they just sat around and talked about drinking stories from college. I wanted to give you something, and hopefully I've done that. So Katie, tell me what to do at this point.
There at the end of your conversation, you actually addressed some of the questions. We received a question of what do you do if you believe opposing counsel or the judge are suffering from debilitating mental condition, which I think you just addressed. Though something that I think might dovetail nicely into that response that you have to go on the record would be the question of how do you get colleagues or yourself help without compromising or jeopardizing their or your own careers?
Without jeopardizing, what was the last 3 words you said?
Their or your own career.
Okay. I think it's all about sensitivity and common sense in terms of the approach you use to these problems. When you're if we assume that a person is suffering from an illness, and I submit that substance abuse is an illness, depression, clinical depression is an illness, you have to recognize what you're dealing with. So whatever steps you take, you have to do it in a respectful and a private way. Therefore, I would suggest to you an approach, and I use this approach with lawyers who had substance abuse problems. If I didn't have to report them, if it wasn't mandated, I tried to talk to them directly and see if I could address the problem that way, recognizing that it was important to protect their privacy rights. But judges are just like lawyers, are afraid to reveal these situations, don't seek help because they're afraid of how it could destroy them. Suppose a judge or a prominent attorney comes out and suddenly announces that he or she is an alcoholic or suffers from depression. And as far as you know from their behavior and practice, you never knew that because they did a great job. In spite of doing a great job, maybe you're going to look at them twice because they've come out and been honest and shared their situation.
And building off of that, another question we have here, Judge Murphy, is what can law firms do to encourage mental health in the workplace?
Okay, I think step number 1 is to, as part of whatever training goes on, bring somebody in who can address the problem of mental illness in general, and then relate it specifically to attorneys. In other words, educate. That's the first thing. Number two, set up some system, and arguably managing partners have this responsibility to avoid situations that amount to violation of ethics rules, not to mention damages human beings, whereby if a person has such a problem, they can report it in such a way and be diverted to someone that can provide appropriate counseling. So those are two steps that I would suggest.
And my final question of the session is one for me. Do you know if you ever had a nickname when you were on the bench, Judge Murphy?
If I ever had what?
A nickname.
Yes, I do. Okay. I was called El Maximo. And I was on the criminal bench for a long period of time. It was perceived by certain people that I always maxed people out in my sentences. So it was El Maximo. Then early on in my career, I was nicknamed the Deacon, and that was because I present myself in such a way that I have very little facial expression and always look serious. So you got full disclosure there. And I'm sure that there were some names even worse. I was called from time to time an asshole in court, once by an attorney, but usually by litigants.
Well, thank you, Judge Murphy. Thank you very much. This has been illuminating and so insightful. You have received a few comments in the chat of folks saying thank you and well done. So thank you everybody for your participation and for attending.